Welcome to the Bobby O Show. My name is Bob Opotzner. I'm an attorney from Danbury, Connecticut. I actually live in Richfield, Connecticut. And for purposes of today's show, I want to let you know that those who do watch the show know this. I'm a litigator, and I spent 15 years on boards of education in two different towns and was head of Charter Revision Committee in my town of Richfield for several years. And I tell you that because the theme of today's show is going to be the rule of law and the protection of our democracy. And I am so thankful to Comcast, which lets me pick my topics every week. I think this is show number 83 or 84 on the Bobby O Show, and I had about 150 shows and other names, and they always let me pick my topics. And I'm grateful for that because having free right to speak and the freedom of speech is very important for you, who the audience of me, and for my guests to be able to express their opinions. Today, I have a superb guest. He is a former classmate of mine at Duke Law School. He became a magistrate judge in the federal court in California, which he served at for 15 years from 2003 to 2018. He was the presiding magistrate judge on the federal court docket in 2017 and 2018. He has now been serving as what he calls a neutral, I would say a mediator or an arbitrator, which is sort of outside the court system, but we'll talk about that in a little moment. But I have as my guest the Honorable Judge, Magistrate Judge, Jan Adler. Welcome, Jan.
Thank you. So nice to see you, Bob, and I want to compliment you. I've watched several of your shows. They're truly outstanding, and it's for me to join you.
That's so very, very, very kind of you to say, because you know how much respect I have for you. We actually hadn't seen each other for a while, but we met up at our reunion a year or two ago. And I met at that reunion a friend of yours, attorney Len Simon, who recently appeared on my show on NIL and other related issues. And by the way, he speaks very highly of you. I think it's important when I have, when I go to court or when I have a guest on the show to know a little bit about their background. And typically speaking, the way I find out about a judge's background is I go to the internet or check it out, because a judge doesn't say to me, well, I'm a Democrat or a Republican or independent or whatever, and I grew up in this town or that town. But it's important, I think, to know a little bit about your judge if you're being a good lawyer. And I actually at one time had a case in which 3 days into the trial, the judge, it was a domestic family matter, and the judge was a state court case, called the opposing counsel and me into her chambers and said, by the way, guys, I want to let you know, I hear your story, and this is almost identical to my life. And the other lawyer and I looked at each other and said, wait a minute, we don't know what that means. And the judge did that. And we said, Judge, we want you to, we consulted for a moment or two, talked to our clients, and we said, Judge, we want you to finish deciding the case. And I tell that story because as part of the rule of law and protection of our democracy, it is critical that the integrity of the judicial system and the legal and the lawyers as well be beyond reproach. And I was so honored that the judge told us that, because we knew what this judge's story was, unlike some cases we're seeing in the country right now, where judges are perhaps a little less forthright. Judge, any comment about that story I just told for a second?
Oh, I think it's really important for the participants in any legal proceeding to know about their backgrounds. I can tell you, when I was on the bench and even now as a mediator in the private sector, I always look up information about the people appearing before me. You have to really be able to connect with people. And so I agree with that judge, and I would certainly handle things the way he or she did, I should.
It was a she. And we were very impressed. Judge, just quickly, your background, where you grew up, and a little bit about 30 seconds or a minute on that, just to give us a little frame of reference.
Sure. I grew up in upstate New York. I was about to say I grew up in a town, but as Bob knows, it was actually known as a hamlet because it was that small. There were no traffic lights, 1,300 people, a dairy farming town in the Catskill Mountains. It also had a lot of resorts in those days for people from New York City to visit. So I grew up in that small town working in my father and grandfather's grocery store. My grandfather established that grocery store when he moved to America in the early 1900s from Eastern Europe. I then went to college at Cornell University. ultimately went to law school at Duke University, where I met Bob, and we had a tremendous, really, really incredibly qualified and intelligent group of classmates. After law school, I began my legal career in Phoenix, where I worked for a defense firm for 4 years. And then I moved to San Diego, where I worked for the next 21 years for a firm that did class action litigation, large, complex cases on behalf of thousands of people in classes. And that was really, really interesting work. In 2003, I was fortunate enough to be selected as a United States magistrate judge in San Diego. Served in that capacity for 15 years. And then I became private neutral, as Bob said, doing primarily mediations. So that's a quick overview.
And Judge, and I'm going to call you Judge because even though on the phone I would call you different than Judge, but I have to show the respect that you have earned. And Judge, we talked the other night in a prep show that we did, as I always do in all my shows, and I'm from a very similar background, middle-class kid, although you may not have been middle class, you may have been a little bit upper class, but we're a middle-class kid from Shelton, Connecticut. My family had a bakery business, not a grocery store, a bakery business. And I will tell you that even today, and even my clients that I talk to, my background, and I'm sure you feel the same way, you can't help but have your background in some way, shape, or form influence how we act as lawyers and as judges, even as people outside the professional ranks. It doesn't make me be prejudiced. I'm sure it doesn't make you be prejudiced, but you can't help but have your background have some input. I always tell my clients that even though I think I've earned the hourly rate that I charge, it still bothers me when I send a bill out for X dollars because I know how hard people work, no matter how rich they are, to earn the money to pay our fees. But your background is a very interesting background. And the way I know you and the way I've seen some of the decisions you write, et cetera, it has influenced you in a positive way, but not a prejudicial way. Comment?
Thank you. Thank you. You know, Bob, if your folks and my folks put together our businesses, it would have been just dynamite. Grocery store and bakery. We should have done that.
That's right. My father once, when I was a little boy, about 7 years old, took me to Stop and Shop, Bradley's. And he was trying to get them convinced to have a bakery portion of that store, and they thought it was the dumbest idea. And then nowadays, everybody goes to Stop and Shop to buy their bakery products. But he was ahead of his time, I guess. Judge, let's talk a little bit about how does one become a magistrate judge?
So magistrate judges serve on each of the 94 federal judicial districts. There are 94 districts throughout the country, one of which, of course, is the Southern District of California, where I served. And magistrate judges are actually appointed by the next higher level of federal judges, known as district judges. So I went through a process. There were something like 73 applicants for the one position to which I applied. A committee of lawyers, retired judges, and community people interviewed those applicants. It was narrowed down to 5, and then the 5 of us, in turn, for about a half an hour each, appeared before the entire group of district judges. So I walked into the chief judge's chambers. There was a chair in the middle of the room. I was surrounded by all these eminent judges, and they started peppering me with lots and lots of questions. And at the end of the day, after the 5 interviews, I found out in 2003 that I was picked as a magistrate judge.
In my litigation practice, I used to do federal court work as well, but I stopped about 10 or 12 years ago because I felt as though if you're not in the federal court system all the time, it's not quite the best way to do it. So I stayed mostly thereafter in the state courts. And I will always tell you that although I always respected state court judges and any kind of judge, probate court judge, there was a certain aura about someone selected to the federal bench, maybe because the President of the United States is involved in the process as well. And so for you to have gotten that position is really a tip of the chapeau for you that you did become a magistrate judge.
Thank you. I would say it was the greatest privilege by far of my professional life. And to this day, I still, as the saying goes, pinch myself that I had the opportunity.
You know, and actually, as I follow what's going on in our society, which we'll get into in a little bit in the show, it amazes me. It amazes me the lack of respect and I don't mean to be political, but we can't help it. And by the way, what I say politically in this show does not reflect what the judge thinks or is thinking. So please don't mesh my thoughts into his, because he's his own person, of course. But to not see respect in the judiciary astounds me. Just astounds me. I mean, I would never I never envision yelling at a judge. I might think it in my head. Jimmy Carter once said he had adultery in the heart. I may have disrespect in my heart on something that was ruled out, but you would never say it. And when you see press conferences after the court hearings and a lot of the charades we're seeing, it bothers me both as a citizen and as a member of the legal community. Do you have any thoughts about that, Judge?
I do. The judiciary is, of course, one of the three branches of our federal system. It plays an incredibly important role in that system of checks and balances. The framers of the Constitution were very, very clear in stating that they wanted a system where no one was a king, no one was above the law. There's an executive, of course, who faithfully is to carry out the laws. There's the legislative branch, the Congress, which is to enact the laws. And there's the judiciary, which is to rule on legal disputes, including whether laws or actions of the other branches of government are in conformity with the Constitution. So there's no question the judiciary, our federal judiciary and our state judiciary, are critical components of our system, of our system of government. It is very, very difficult, as you say, Bob, to see what is happening now in society. And this has been going on for a while. I think it has gotten worse in recent times. There's no question citizens have the right and the opportunity to exercise their freedom of speech and expression, to state whether they disagree with a judge's ruling. But what's beyond the pale and what is so concerning are the number of threats that have been made to judges who rule against certain parties' positions. There have been death threats. There have been threats to families. There have been family members who have been killed, judges who have been killed. This is just a terrible, terrible development, and it just cannot go on. The proper thing for someone who disagrees with a judge's decision is to appeal within the system to the next level of the judiciary. And if they disagree with that decision, then they can appeal to a higher level, ultimately to the Supreme Court. But no one, no matter how vigorously they disagree with a judge's decision or a court's decision, should make threats like this. The number of threats against federal judges has increased so exponentially that the United States Marshal Service, which is charged with the protection of federal judges, is having a hard time really literally monitoring and dealing with all of these threats. And so this is a very negative development. It pains me greatly to see this happening. And no one, no matter what their views on either side of the political spectrum, should act in this manner. It's a tremendous threat to our democracy and the rule of law.
So very well stated, sir. That was just amazing statement of what your position is and what your thoughts are in this regard. The situation has gotten so bad that one thing that struck me is that Amy Coney Barrett, who's a justice of the Supreme Court, is a Trump appointee and usually votes in a direction I don't like, although she's much better. I think she's been a better Supreme Court justice than I thought she might be. And yet her sister was threatened with something that happened over a vote that she made. And that's just obviously not right. And the second thing is, you need to have the best and the brightest, in my opinion, become judges. And I don't know, and I wouldn't ask Judge Adler now, but if it were now, instead of 2025 now, if this were now when he was being considered as a magistrate judge, who knows whether he and other quality judges like himself would have said, you know what, I'm better off staying in private practice, probably making a lot more money, and not dedicating myself to be a civil servant. And so not only do you have the threats to the people who are judges now, but what about the future judges? That's a concern as well to be considered.
I agree. I agree. There's a real chilling effect that can occur. You know, our federal judiciary consists of incredibly courageous, qualified, intelligent men and women who have been going about their duties, notwithstanding these threats that have been made to them. An example. There's a judge in the Western District of Washington in Seattle who I believe had one of the very first cases on the birthright citizenship issue. This is the issue that the president, very early in his term, I think on the very first day, issued an executive order trying to revoke the rights of people born in the United States or naturalized in the United States to be United States citizens. The plain language of the Constitution does not support that executive order. And the judge in Seattle found very emphatically that the position of the administration was at odds with the Constitution. He courageously set forth his opinion. He said it in very, very stark, emphatic terms because he felt it was essential that this aspect of the Constitution not be violated. And he has received numerous death threats. Yet he continues every day as a federal judge. And this is just one example of people all over the country who, notwithstanding these threats, continue to do the essential work of the federal judiciary. But there's a real concern that some people may look at this system being under threat and people being under threat and decide they don't want to expose themselves or their family members. There's a magistrate judge who is in the District of New Jersey who issued a decision that a party to a lawsuit did not like, was very upset, came to her door looking to assassinate the judge. The doorbell was rung and answered by her son, and the son was killed. This just can't go on, no matter, again, whether it's a judge who has leanings one way or the other in his or her opinions. That just cannot happen for the system to succeed and to function as it has for nearly 250 years.
You know, and as you talk about this, we as judges, you as judges, except the Supreme Court justices, we'll get to that perhaps a little later, and we as lawyers have ethical obligations in the practice of our law. And there are things that I think that lawyers could do better to tamper things, to get things down a little emotionally. For example, we have an ethical obligation to file pleadings. Pleadings are papers that are filed as part of the court process. And you have to file what the ethics say, good faith pleadings. Now, when you talk about the citizenship issue, which couldn't be clearer in the Constitution, you know, if whether we like or don't like the citizenship statute or the citizenship provision in the Constitution, that's the law of the land. If people want to try to change the law and amend the Constitution, there's a procedure to do that, but that's the law of the land. So when lawyers are filing papers in court for a position that they know is unconstitutional, that's violation of ethical considerations. And I think lawyers need to tell their clients. I've said no to clients. I've had clients who I've said, you know what, we can't be attorney-client anymore because I don't agree with what you want me to do. It's not a matter of having a good faith disagreement, but rather you want to go against what the law is and I won't do it. And I've had clients say, well, Bob, if you won't do that, I'll go elsewhere. And I say, that's fine. But I think lawyers, now we can't prohibit someone and make someone not make a threat. I mean, we would know that if we did know a client was make a threat, we have an ethical duty to breach attorney-client privilege. It's not privilege anymore, to call the police, to do things like that. But I think lawyers are somewhat culpable by not telling their clients no. Sometimes no is the right answer, just like Nancy Reagan said. Any comment about that, Judge?
Yeah, there's an old saying that be a zealous advocate, but not a zealot. And I've always found that to be a very useful description or summary of the way lawyers ought to conduct themselves. A lawyer appearing in court has an ethical duty, as you said, Bob, to make sure that he or she cites cases and legal principles correctly without misrepresenting what the cases say. They have an equal responsibility, ethical responsibility, not to misrepresent the facts of the case. They need to conduct themselves civilly, professionally, with the appropriate decorum in respect not only of the court, but the court staff. It is always incredibly upsetting when I see lawyers not treat court staff respectfully. They need to be treated respectfully. The opposing lawyer needs to be treated respectfully. The system just does not work if civility and professionalism go out the window. And then there's another thing. When a judge issues a decision, it needs to be obeyed. It needs to be complied with unless and until it's reversed by a higher court. One of the things that, again, is so concerning to me in our present legal environment is that a lot of court orders are not being heeded. In fact, they are being not only not heeded, they are being violated. And this has happened too many times. There was a Washington Post article recently that I read, relying on data that some law professor, I believe, had assembled, that something like 1/3 of the substantive decisions issued by federal district judges during this year have been violated, those orders. That just cannot stand. That is, to me, a very alarming development. And we see that in combination with personal attacks on the judges. There is a judge, for example, I'll give you another example, Bob. There's a judge named Judge Boasberg. He is in he's a judge in Washington, D.C. on the district court there. And he has issued a number of decisions in regard to deportations of immigrants, allegedly unlawful immigrants. And a very famous situation where he told the Department of Justice lawyers that they could not send certain of these alleged unlawfully here immigrants to El Salvador or other countries. I believe it was El Salvador. And notwithstanding that, the plane took off and left. And that's a direct violation of a court order. That's just one example. Again, that cannot stand for our system to survive and the rule of law to prosper and contribute to the checks and balances that are so essential to a democracy. What happened after that? Judge Boasberg, in a private conversation, allegedly with Chief Justice Roberts of the Supreme Court, expressed his concern in a conversation where others had said they were concerned about the lack of compliance with court orders. The next thing that happened, the Department of Justice filed a disciplinary complaint against Judge Boasberg for making that statement. Again, that is an effort to chill the judiciary, and it's just not appropriate. No matter what one's politics, no matter what one's party affiliation, no matter what one's viewpoints.
There's a lot you said in that statement a few moments ago, and I just want to make a couple of comments in that regard. First of all, Judge Boasberg is a Yale graduate who played on the Yale basketball team and was an excellent basketball player. And he also went to Yale Law School, and he roomed purportedly with Supreme Court Justice Kavanaugh, which raises some questions in my mind. If that's the case, I don't know why Judge Kavanaugh did not recuse himself from the decisions he made on some of these cases, especially the Boasberg case. I think if I had a case before that was going to be before you, I know darn well, I was going to say damn well, I know darn well you would have said, remember, Bob, we were friends at Duke Law, et cetera, et cetera. Maybe we should get another judge appointed. but that's because you have integrity. In our Supreme Court, which is what I'm getting into, as far as I'm concerned, has members who are not. And you mentioned the last year, things has been the 1/3 of orders have not been followed. I think the Supreme Court and the Department of Justice take a very big responsibility. I got to tell you, in the last year or two, I found clients ask more about, do I have to really follow that court order? In the past, I probably got asked that question more in the last year or two than I did in the first 38 years before that. And the Supreme Court, and we'll get into the shadow docket in a moment, but the Supreme Court's handling of the Boasberg decision and the word they used that gave some wiggle room is ridiculous. And the Department of Justice making decisions not to follow the court order. And Judge, you and I both know, if a judge issues an order from the bench means everybody, it's not written yet. The judge says on the record, because sometimes there's reason to say the right decision from the record, from the bench. And then the judge sits down and writes down carefully exactly what his ruling is. To me, it's as much a court order if it's oral as it is in writing, and you follow it. And if you advise your client not to follow a court order, I think that's grounds for ethical action against the lawyer. And it bothers me when I hear these things. I think you may have some more comments on that, or we go to the next topic.
Yeah, I agree with you. And Bob, it's really very, very perplexing and dismaying to me as someone who's been in the legal system for over 40 years now, to hear that clients are saying, I have to obey a court order. That to me is a really, really big red flag. It just is really something that threatens the very fabric of our legal system and the rule of law. There's one other example I want to give about something that happened recently. Again, it's in the immigration area. So look, people have different views about this. I understand that. And people are entitled to their viewpoints. But we have this concept in the Constitution, this requirement of due process, where every person that appears before our courts in our legal system has the right to present argument, to present their viewpoint, to be represented by counsel in doing so. And there is a procedure in our Constitution called habeas corpus. It's also known as the Great Writ. And so what is that? It is a means of challenging the legality of one's confinement. So the District of Maryland issued a rule, I should say, that no deportations of allegedly unlawfully present immigrants could take place for 2 days while a habeas corpus petition was under consideration by the court, just for 2 days, to prevent the situation from becoming one where the immigrant would have no opportunity to exercise his or her rights of due process. What happened? The administration has sued, believe it or not, has sued every judge on the District of Maryland, that's 15 federal judges, in an effort to cow that court into not having that rule, that common sense rule. This is just unprecedented behavior, and that suit was filed by the Department of Justice. When lawyers take positions like this, when lawyers do that, they lose credibility with courts, and they damage their standing before the courts, and they damage the effectiveness of court proceedings. One of the most beloved judges in our district, a man named William Enright, gave me a lot of great advice when I became a new judge and even when I was a lawyer. And one of the things he said to me is, your reputation is everything as a lawyer. That's not only true for lawyers, of course. And when lawyers take positions like this, they damage not only their own reputations, but the reputations of their law firms or the Department of Justice, in my example. And it is a very, very big problem for the functioning of our legal system.
Couple of comments I want to make. First of all, I do want to clarify that 98% of my clients are going to follow the law and do follow the law. It's just a couple percent who may ask the question, often in the discovery process, which is when you have to give information to the other side. Well, why do I have to give that document or not? Well, the court order says so, but it's only that small percent that I was referring to. Number two, I want to make the comment that due process, you hit the nail on the head, is a very important issue. As far as I'm concerned, the issue about Garcia, who was a person who was not supposed to go to El Salvador, but was sent to El Salvador, if he were really a criminal, I'd drive the bus to get him out of the country, or anyone. And I think the judge probably would also. But the issue is, just because the Department of Justice says so-and-so is a criminal doesn't do it for me. It's the issue of due process. So when I heard even some congressmen, when they were asking questions of certain people and witnesses and saying, "Oh, so you want to protect the criminals who do violent crimes over based upon due process clause?" The answer is yes, due process. Didn't President Trump get due process of law in his trials, even though the jury came out with the 34 counts of felony conviction? He had due process, and President Trump used every single angle he could use. Well, just because someone is poor, or maybe his or her skin color is different than mine, or because of male or female, or what their gender position is, they still have the rights. And I'll just read to you, and I always carry the Constitution with me, and I just want to read from the Constitution, where it starts out saying, "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promotion of the general welfare," and it goes on from there. But it says, "We, the people." It doesn't say certain kinds of people. It says, "We, the people." And that frustrates me tremendously. I have a third point, but let me just give the break now for the judge to make a comment of what I just said.
Well, I will say this. Due process takes time. There's no question about that. The examples we've been talking about, and probably one of the biggest hot button issues there is out there, with, again, acknowledging people have different viewpoints on this. It takes time. And I know the administration, from the president on down, have said that if we had to give every person due process, we'd have thousands upon thousands upon thousands of court hearings. Well, that's how our system works. That's what our system is. That's the hallmark of our system, to give every person, as you said, Bob, no matter how poor, no matter how difficult their circumstances are, whether they're rich or they're not, everyone deserves due process. And when I, as a judge, and when every judge takes the oath of office, all of us have to pledge that we will follow exactly that, give every person due process. So that is our system. That's the probably the most fundamental aspect of our system.
And there'd be fewer cases to worry about if the prosecutors, the Department of Justice, did their job and looked and see if the case really has viability. You wouldn't have to bring cases as many times if, in fact, the prosecutors said, "You know what, we can't win that case," or "it's flimsy," or "we don't have the evidence." Then you wouldn't have to waste time. This Garcia case, I don't know how much it cost the United States in terms of dollars and cents, but it's got to be millions and millions of dollars in court time as well. And I think that's, it's a false argument to say, "Oh, well, we'd have a million cases." You know what? Someday that case might be your case, or your kid's case, or my case. I do want to jump to one thing. I promised I had some questions from some law school friends of ours, and I have one from Nancy Halleck. Remember Nancy Halleck?
I remember Nancy, and I don't know if Nancy's watching, but I remember you so well, and I send you very, very best wishes.
she's part of a crew of people who we annually, I didn't go this summer, I couldn't do it, but there are 5 of us who went to Duke Law in the New England area. That'd be Howie Levin, Ed Ribzik, Nancy Halleck, myself, and we go somewhere in Vermont or New Hampshire or whatever and have lunch together. And I mentioned to them that you were going to be on the show today, and I think a few of them are watching. But here's Nancy's question, which I think has been answered in part, but I'm just going to give her the credit of her question. She said, what are some of the implications for how the lower courts will handle cases post-Trump versus CASA, CSA, not just the birthright issues, but other issues such as detaining and deporting undocumented immigrants, abortion pill, and environment? That's an easy yes or no question. No, it's not. It's a very complicated question, a very good question. And Judge, I don't know if you have any more you want to add to what we've said so far, but it's really an excellent question.
It's, as I would expect of Nancy, it's a beautifully, insightfully framed question. So Trump versus CASA was a case that came before the Supreme Court with the underlying issue being the birthright citizenship issue that we discussed earlier. But the court didn't take up the substance, the merits of the issue, and that is whether birthright citizenship can essentially be annulled by an executive order. Instead, what it did was take up the issue of whether a federal district judge sitting in any of the 94 districts around the country can issue what we call an injunction. That is an order when the judge finds that there is a likelihood of success on the part of the person challenging the order and certain other factors that have to be determined. If that judge issues an order halting the practice that may ultimately be determined to be unconstitutional, that's known as an injunction. And federal district judges across the country in recent years have issued what we call nationwide injunctions. So not only applying to the people before the court, but people all over the country. In other words, not just the parties to the case, but everyone who is affected by that order. So the Supreme Court decided by a 6-3 vote that nationwide injunctions are not proper. And this was over a very, very spirited dissent written by Justice Sotomayor and joined in by Justice Kagan and Justice Jackson. And what is the effect of this? It means that an injunction issued by one federal judge can only apply to the parties before the court. And the concern expressed by Justice Sotomayor and her colleagues in dissent was that that takes away the most potent remedy to address a problem of nationwide concern, such as the birthright citizenship issue, I should say. So what this means, and I'll get to how litigants are trying to get around this. What this means is that a citizen who appears before a judge in, let's say, San Diego, if that citizen gets an injunction saying that the president's executive order banning birthright citizenship is unconstitutional, the injunction only applies to that citizen, to that party. And what that leads to, ultimately, in the view of those who are against this Supreme Court decision and disagree with it, is that you would have to file cases all over the country. And courts could conceivably, although I don't think they should on this issue, they could conceivably, on whatever issue it is, come out with different rulings, which means you'd have chaos. What has happened and what the Supreme Court left open is that other procedures, other remedies can be utilized. One of them is the class action device. And for those in the audience not familiar with it, a class action is a lawsuit filed in the name of one or more plaintiffs, one or more parties, the moving parties, and they seek to have a class of all people affected by the order or the practice certified by the court, meaning that the action will proceed on behalf of that group of people. Could be hundreds, could be thousands. It's a large group generally. And the court said that you can still use the class action device. Class actions are somewhat cumbersome. It takes a lot to get a class certified. I know this because my practice when I was with the firm here in San Diego for 21 years was a complex practice involving class actions. You have to satisfy a number of requirements, and you have to show that the order affects everyone in a common way and that individual issues do not detract from the common issues. The common issues have to be what we call predominant. So it's not easy to get classes certified. Notwithstanding that, a judge in a district of New Hampshire recently did issue an order certifying a class in one of these birthright citizenship cases, reasoning that the executive order applied in a common fashion across the entire group of people affected by it. So that's one way that lawyers are trying to deal with the outcome and the ramifications of this case that Nancy mentioned in her question.
Your Honor, can I interrupt for 1 second? I want to just put a couple of comments because when you and I took constitutional law, same class, and at Duke Law School, there was one small section for various topics. And other than that, we took all the classes together, and we had a phenomenal constitutional law professor named Van Alstyne. And we spent the first month of the freshman year, first year, studying Marbury versus Madison, talking about judicial review. And I didn't understand then why I spent so much time studying it, but I did understand it after I became a practicing lawyer. And the thing I want to say to you is that what we learned is that, typically speaking, the court tries to be, in my opinion, and I think opinion of a lot of other people, minimalist. In other words, if there's a case involving me, where there's a constitutional issue of significance, and maybe there's 3 or 4 issues that don't need to be decided at that point in time, the Supreme Court should try to and did try to deal with the significant issue. And one of the beefs of the conservative people was that there's this activist Supreme Court, and we don't want the Supreme Court being too activist. And they complained about that on the abortion decisions, on Roe versus Wade, that kind of thing. So I think that lesson is important. So if you take that to what you just discussed about whether a district court judge in one state could impact laws throughout the country, remember the people who wanted to have the right to use that abortion drug, and there was a Texas court, federal court, that ruled against it, and then the effort was to try to make that one decision go nationwide. That could be a problem, shall we say, conservatives versus liberals, and vice versa. That's why when the Supreme Court recently said what you just ruled, I thought, gee whiz, there might be an intermediate step they could have taken, which would have been maybe if the law is so clear, like the citizenship case, so crystal clear in the Constitution, then in that kind of situation, we would uphold the injunction. But if it's a case where it's a 50-50 decision, one or the other, maybe you wouldn't uphold that. But the Supreme Court,
Bob, if I can jump in exactly on your point, there is language in the majority opinion in the case that Nancy mentioned, Trump versus Casa, that says that a nationwide injunction may be properly issued in a case where it is necessary to afford effective relief. Now, what does that mean? The devil's in the details, as always. And a lot of times, higher courts, especially the Supreme Court, issue pronouncements and then expect we in the lower courts to flesh that out and apply them. So your point, I think, is well taken. And we may see that happen. We may see rulings by district judges relying upon that language, and who knows where that will go.
Thank you for your comment. And I guess what I was really saying was the language wasn't strong enough because it hasn't achieved our result. And remember, you and I know this, for an injunction, at least in Connecticut, it's got to be irreparable harm with no adequate remedy at law. Irreparable harm with no adequate remedy at law. So when the Supreme Court is hearing the federal government on some of these cases, where was the harm to the government by having the injunction stay in place versus the person who's got to be in jail for 4 months or 5 months or whatever? What the harm is so much different for that person. But this is the kind of discussion that the judge and I and Nancy Halleck and our friends at Duke and lawyers across the country have all the time, because the law is often, usually, primarily not black and white. And I think the Constitution was written that way because the documents lasted for almost 250 years or 240 some odd years, because it's got to be a dynamic document. Judge, I'm going to change to a different topic, if I might, and if you could in this situation. That is ethics. The Supreme Court is the only body that I know of in the United States that does not have ethical rules that are requirements that they upheld. I know that Justice Roberts tried to do something that I thought was smoke and mirrors, with all due respect to the Supreme Court Justice, Chief Justice. But I think ethics are a real problem in our country now. And one of the things that bothers me, and perhaps you might give your comments on this from a judicial perspective, we have the second or third in command, the Department of Justice, Blanche, who represented the president in cases involving the president from criminal and other perspectives. That was his lawyer. Now we have a situation where that person is now on the Department of Justice, number 2 or 3 in the top rung. And he goes and meets with Maxwell, who's involved in the Epstein situation. And the question in my mind is that attorney involved in this discussion with Maxwell on behalf of the Department of Justice, on behalf of Donald Trump personally. And I think there are ethical issues to be considered. I don't know how he can be in the room with Maxwell, and then who knows what recommendations. I know she was given a more lenient, they call it a country club camp. I don't know what that means in Texas, but it's a lot less restrictive. But how could the ethics of that lawyer allow him to act in that capacity? You don't have to answer the question on that case specifically, but generally speaking, the importance of ethics by the bench, by the lawyers, by the clients in our system of rule of laws.
It's absolutely critical, Bob. I'm glad you asked the question. We've touched upon it a bit earlier, but as lawyers, we have ethical obligations that we talked about earlier. And judges also have ethical obligations. And one of the foremost ethical obligations of a judge is to be impartial. Again, we take an oath when we're sworn in that requires us to pledge under oath that we will treat all people who come before us, no matter how rich or how poor, no matter how advantaged or disadvantaged, the same way. And we cannot exhibit any partiality. You mentioned earlier, Bob, if you appeared before me or you had a case where you were listed to appear before me, I would not take that case. I would recuse. I would, what that means is I would not take the case, and another judge who had no connection to you would hear the case. Not only must we be impartial, but we have to make sure that we do not have any appearance of partiality. We have to make sure there's no appearance that we favor one side or the other. So these are just some examples of why ethics codes are important. The lower federal judiciary, that is the district courts and the appellate courts, other than the Supreme Court, have long had a code of judicial ethics. There are canons, as they're known, of judicial ethics. And we always had to abide by them. The Supreme Court, for years and years and years throughout its history, never was required to abide by that code of ethics, although as Chief Justice Roberts said, they consulted, in his words, and they consulted other pronouncements of, for example, the American Bar Association and other organizations to make sure that they were acting ethically. Well, what happened is that in recent years, Justices Thomas and Alito, just as two examples, it's not only Alito and Thomas, it's not only them, but those are the most prominent examples. Each of them accepted many gifts, and these gifts were something that no other federal judge would ever properly accept. But there was nothing that barred them in a code of ethics at the Supreme Court from doing so. And so there was a tremendous clamor in the legal community and in the public at large that the Supreme Court adopt a code of ethics. And it finally did so in November of 2023. As Bob said, it's been criticized very heavily. There's no enforcement mechanism. You know, as lower federal court judges, there are enforcement mechanisms. If we violate a canon of ethics, a complaint can be made, and there will be a ruling upon it, and there are consequences for doing that. And they can be very serious consequences, but there's no enforcement mechanism for the Supreme Court to abide by these new ethics, by the new ethics code. And so it isn't perfect. I think it's positive that there finally is such a code, but it's critical for the legitimacy and the public perception of legitimacy of the judiciary that every judge, no matter whether a judge in San Diego or a judge on the United States Supreme Court, abide by these ethical precepts.
And, you know, there's a lot of written rules in terms of ethics. There's also other non-written rules that are norms. And everything doesn't have to be written down. I'm sure lawyers in the 1940s, when they didn't have all kinds of computers and typewriters that are fancy things, did a lot of things on handshakes. And now that we have everything that can be written down and memorialized, et cetera, it's got to be in writing. But I'll give you a quick example of two situations where lawyers just automatically did the right thing. One is that I'm involved in the tail end of a case in which a paper was going to be filed by the other attorney. And the client said, well, gee whiz, can you accept his word for that it's going to be filed? And I said, if attorney X says that it will be filed in 20 minutes, and it was filed in 20 minutes, then I can trust him. And actually, when I wrote that note back to the lawyer wrote me back saying, you know, Bob, it's such a pleasure doing business with another attorney who can take my word for it and vice versa. That's what makes practicing law appropriate and fun still. And I had another thing in the same exact case where a lawyer that was going to be involved in the case forgot that he had a conflict of interest. The conflict was from 6, 7, 8 years ago, and he forgot. And I called up and said, by the way, do you know so-and-so that you were involved in this thing tangentially for 5 minutes? And it wasn't 5 minutes, it was a very limited amount of time. He said, you know what, you're right. And he immediately, without question, said, you know what, I'm getting out of this case. I can't get involved. That's what you need in our legal system. And I think part of the problem we're facing, and this is where I think Trump and Bondi and the DOJ, Department of Justice, are being short-sighted, is that the credibility of the Department of Justice has been diminished exponentially. I guess what's the reverse of exponentially, but it's the opposite of exponentially. And if Pam Bondi said to me today, and I had a case with her, which I never have had a case with her, said, Bob, I'll file something in 20 minutes. I want to have that sealed in gold, and then I still wouldn't believe it. And that's not the way. That's not the way, in Bob Opotzner's opinion, that the rule of law works, and that's not how we will have a good society that fulfills our constitutional requirements. Judge, any comments on that?
Well, again, the system cannot function unless lawyers discharge their duties in an ethical manner. And it's so critical that lawyers only make arguments, as the ethical rule says, that are either supported by law or by a good faith extension of existing law. You cannot misrepresent facts. You cannot misrepresent law and expect that judges will not be very, very upset. And look, these federal judges are very, very intelligent, and they're very, very competent, and they will know and they will call out anyone who misrepresents facts or law. So,
by the way, Judge, in the case, if the three lawyers I mentioned, myself, there's other two lawyers, the judges we go before all the time, they know what I said is the case, and they know our word is good. Judge, I want to ask you one quick question, then I'm going to give you a summary to give some advice to young people who want to become lawyers. Even we've talked a lot of negatives today, but it's still a great profession. But my one last question, if you can answer briefly, also from Nancy Halleck, can you explain the shadow docket and how does that impact our judicial system when the Supreme Court does not give written decisions, just says yes or no, so to speak?
Sure. The shadow docket is a phrase that has been used to summarize this situation. So many, many orders of district judges have ruled, many of the judges have ruled against the administration. But that happened in other administrations, the Biden administration and others. It's always happened. What has happened now with increasing frequency, and it did happen during the Biden administration and others as well, but with increasing frequency, what this administration is doing is making what they call emergency appeals to the United States Supreme Court, in many instances bypassing the courts of appeal, which are the intermediate appellate courts in our system between the district courts and the Supreme Court. And the Supreme Court has taken up many of these issues. A lot of them have had to do with the firing of federal employees. A lot of them have had to do with immigration. A lot of them have had to do with really, really very critical issues for our society and our legal system. And what the Supreme Court has done time after time after time, something like 18 or 20 times now, is what we call stay or hold in suspension a district court order. And that means the district court order finding an executive order of the administration or some practice of the administration to be unconstitutional. That order is stopped. It is halted in its tracks without the court having a hearing, without what we call full briefing, where the lawyers present detailed legal arguments, without the court being able to have the kind of conferences among themselves and consultation about these issues. And so what has happened is this has become known as the shadow docket. And I think it's a very, very dangerous situation.
Judge, you're absolutely correct. Unfortunately, we're out of time. And just one quick thought in this regard, and that is there's a phrase called stare decisis, which means using precedent. And if you don't know what the rationale was in the decision, how could it be precedential?
Exactly.
Judge,
Bob, I wanted to say that,
Judge, I'm sorry. This has been a phenomenal show. I look forward to seeing you on the West Coast, hopefully in February when Duke is playing 2 games in the West Coast. I'm going to have you back if you don't mind, Judge. We're going to have you back because this has been an extraordinary opportunity to speak with you. Thank you so very much. This has been Bob Opotzner and the terrific retired judge, Judge Adler. Thank you very much.